Lights, camera, action, that's it. Lights, camera, action, that's it. Lights.
Hello. Welcome to the Faculty of Law, University of Lagos channel. It is my pleasure to invite you to this series where students have discussions on different aspects of the law. Once again, my name is Professor Adekile, and here in the studio with me are the critics team.
Yeah.
As they take us through another issue in the law of tort, I would like you to remember to comment, like, share, and subscribe to the channel. Thank you very much. Now, I would invite the critic team, who I expect to introduce themselves, to tell us about what they have today.
All right. So hello everyone. My name is Grace. I'm a 300 level student of this incomparable Faculty of Law. Yes. Yeah. Thank you. I'll be passing the mic over to my partner here.
Hi everyone. My name is Lawrence Uchendu, 300 level law student as well of the incomparable Faculty of Law. It's a pleasure to be here with you, Ma, to criticize this area of law. Thank you.
Great. I really look forward to this critical perspective.
Yeah. Yes.
So you are the critical group.
Yes.
Okay, so Grace, can you give us what case scenario do you have for us today?
All right. So our case scenario has to do with defamation, and it's very interesting because it's something we experience every day, especially with the advent of social media. Here our question goes. Mark is an upcoming singer who was signed to Tory Sings, the owner of record label Singers Connect. Their relationship eventually soured and Mark got fired from the label. Mark, aggrieved by his dismissal, paid an Instagram blogger to make a post about Tory Sings. Significant portions of this post stated that record label Tory Sings is known for mistreating singers under his label. He recently fired Mark and is known to have improper relations with other singers. In fact, have you seen the 3-year-old daughter of former signee to his brand Thrills? The girl bears a striking resemblance to Tory Sings, showing that he is indeed the father of the child. This post gained traction on Instagram, and other blogs reposted it on their pages as well. Both Tory Sings and his label were cancelled on social media, and as a result, some partners of Singers Connect called off their partnership, stating that they refuse to be associated with a brand that has been publicly shamed. So the question in this case is to identify the potential parties in this case, the relevant issues, and the remedies that are applicable. Wow.
It's very interesting.
Yes. So I think this resonates with this generation.
Yes.
It's what we experience daily, like she said. Mm-hmm. Okay, thank you very much, Grace. Lawrence, can you please speak to this issue, to this case scenario by identifying the issues and just talk generally about what you think about it?
Yes, absolutely, Ma. Thank you so much. So, in the first leg, we'll just be giving a definition of defamation, and then from that definition, draw out certain elements that will then inform the issues that we'll be raising concerning the case scenario. And for that, we'll be drawing from the definition preferred by the court in Abalaka versus Akinsete, a 2023 case, which defined defamation as any publication of a statement concerning a person that is calculated to lower him in the estimation of right-thinking members of the society, and also maybe cause him to be ridiculed or avoided. And from this definition, you can see certain salient elements being, a statement made by the defendant, made concerning the plaintiff, published to a third party, and then also no legal justification for such statements. And so we've raised 7 issues on the strength of these elements. The first being whether or not the plain statements were defamatory. The second being whether they refer to Tory Sings and whether they were published to a third party, right? And then the fourth being whether or not the Instagram post constitutes publication. And then the fifth is whether the multiple publication rule applies to concerning the reposts that were made online by other blogs. Yeah. And the sixth, help me with the sixth.
It is whether any defenses are applicable to Tory and the Instagram blogs that posted it as well. Okay. And for the last part, we're just going to look at remedies that will be applicable to both parties in this case.
Perfect.
So those are our 7 issues. I hope you are ready for us to criticize them.
Yeah, the critical group. Okay, that's very good. Very, very good. So what you are telling us essentially is that this case scenario takes you through the old gamut of the tort of defamation.
Yes.
And but from what you have said, you might say that these issues that we have identified actually resonate with the elements. The issue of whether it is defamatory, whether it refers to the plaintiff, and whether it is published. And then you have these sub-issues that attach to them. That's great. So, Grace, would you like to speak to the first issue?
Yes, thank you very much, Ma. So the first issue is whether or not the plain meaning of the statement is defamatory. So what is the plain meaning of a statement? It is how a reasonable man will construe that statement without you having to impute any other meaning to it. This definition has been affirmed by the court in cases like Omar Sage versus Okutobo, where it was held that the plain meaning of a word is how reasonable men will construe it. Also, we see what Lord Reid says in the case of Lewis versus Daily Telegraph, where it is how words are understood by the people that are listening to them or by reading them. It has also been affirmed in cases where, by Lord Selborne in the case of County Bank versus Henry and Son, where the question you ask yourself is, how would a reasonable man interpret this? Let us stick with you. So in this instance case, they've said that the singer guy, Tory, he mistreats his co-workers, that he's even going as far as accusing him of improper sexual relationships with somebody that he has worked with in the past. You don't need somebody to add 1 + 2 for you to say that this is clearly defamatory. So in this case, our conclusion is yes, the statements that were posted on the blog are clearly defamatory on the face of it.
Great.
Awesome.
Lawrence,
Yes, ma'am.
would you like to speak to the next issue?
Yes, the second issue questions whether or not the statements refer to Tory Singhs. And much like the first issue, it's a bit direct, being that the statement itself was made with reference to his name, Tory Singhs. Going on the strength of the fact, it says that the blogger stated, or the post stated, that record label owner Tory Singhs is known for. So it clearly speaks to the person of Tory Singhs. And so there are a lot of authorities or cases that have decided on this particular issue. And one of them is the case of Service Press Limited versus Nnamdi Azikiwe. And in this case, there was a publication which contained the name Ben Azikiwe. And the plaintiff brought this action, right? Nnamdi Azikiwe brought this action to court and contesting that the publication was defamatory to him. And the question before the court was whether the statements that was made in publication referred to him, right? Him, which is an element of this law of this tort. Yeah. And the ruling was because the name Ben Azikiwe was not Nnamdi Azikiwe. Just like saying two brothers having a same surname, and then a statement made to one is now taken as a defamation to the other. So that doesn't count. Yes. It has to be directly at the person. And so in applying this case to the scenario at hand, it is clearly defamatory to Tory Singhs because his name was mentioned in that publication. Yes, ma'am.
Okay, so you're saying that in terms of reference to the plaintiff, there is an established case in that respect.
Yes, ma'am.
Okay, so Grace, what next?
Okay, so the next thing we have to consider is whether or not the statement is actually defamatory to a corporate body, and the name of that corporate body is Singers Connect. So when we're talking about defamation generally, we know that defamation has to do with the feelings of a person. So the general rule, we know that a corporate body does not have feelings. So right, a corporate body cannot be defamed in its feelings. However, this is law. For every general rule, there is an exception. Yeah. So in this case, in the case of Basi versus Edom and another versus Ophio Nigeria Limited, it was stated that a corporate body can actually be injured in its reputation and in its goodwill. Also, in Lewis versus Daily Telegraph, it was also held that a corporate body can be injured if it affects its pockets. So the goodwill is the attractive force that is attracting people to come and patronize a brand, and then the pocket is actually the finances, its customers, maybe its partners, and so on and so forth. So if we want to apply this to the case, now you see that our question does not expressly mention the name Singers Connect. However, I mentioned Tory Singhs and says that he's a record label owner. So in a way, we can deduce that, Singers Connect is somewhere related to the defamatory statement. Now, to prove that the statement actually affected the pockets, you will see that in the later part of our question, some of their partners refused and called off their partnership deals with them, stating that they don't want to be associated with anybody that has been dragged on the internet. Thus, in this case, we can conclude that even though the Singers Connect is a corporate body, it does not have feelings. However, it has been injured in his pocket and in his goodwill because some of his partnerships were lost. So that's our conclusion on that issue, ma'am.
Fantastic. So what you're saying is that the likely plaintiffs include Tony,
yes,
and even Singers Connect,
yes,
as a corporate entity.
As a corporate entity.
Yes, that's always important in terms of who has the capacity to sue in the tort of defamation.
Yes.
And they have given us both the general rule and the application,
yes,
and the exception. Thank you very much. So Lawrence, over to you. What would you like to speak on again regarding this case scenario?
Yeah, so I'll be raising the next issue, which is whether or not the Instagram posts amounts to publication.
Okay.
And placing particular context to publication here, I'll start by saying that one key determinant of whether defamation is either slander or libel, right, is the form in which it is published, right? And so with respect to this particular question, we have an Instagram post, and a lot of us are familiar with the Instagram platform. Mm-hmm. So an Instagram post amounts to publication in the context of technological publications, yes, right? And so in the case of, let's take for example the case of Instagram versus Instagram, the court held that a fundamental aspect of libel is not in the writing but in the publication. Right? And in this case we have a publication that is permanent online on Instagram. Okay. A lot of people, in fact it was stated that there were a lot of reposts, yes, right? And pursuant to the Cybercrimes Act, I believe section 24 subsection 1B clearly states that a person who sends a message or other matter by a computer that knows that statement to be false is create annoyance, inconvenience, danger, insults, and the likes, is liable to a term of not more than 3 years. So it is defamation.
Yes, it's clearly codified.
Clearly defamation. And so we then go on to the case of Mutual Aid Society versus Adekile, and particularly stating this case because the publication was not made by Mark, right? It was made by an Instagram blog for Mark, right? But on the strength of agency relationships, yes, right, he who performs an act by another is taken in the eyes of the law to do that act as himself.
Yes,
facit per se, exactly. And so in this case, it's clearly stated that any defamatory statement that is made by an agent will be taken as that is made by the principal himself. And so taking us back to our issue, whether or not the Instagram post amounts to publication, clearly, yes, it does amount to publication on the strength of the cases and also the Cybercrimes Act. Okay. Yes, ma'am.
Thank you very much, Lawrence. So what Lawrence has said is that there is publication. Of course, you know that publication means that you communicate the statement to a third party apart from the plaintiff himself. Yes. So the moment that Mark communicated it to the Instagram blogger, yes, he had already committed the total defamation. Yes. So it's another level of defamation when the blogger now puts it online. Yes. Okay, so those fine distinctions must be made. Thank you very much, Lawrence. So Grace, over to you. What is the next issue that we want to look at?
Okay, so the next issue is whether or not the multiple publication rule applies in this case, especially in relation to the traction that this post got on the internet and the blogs that reposted it. Yeah. So the general rule in Nigeria still maintains the common law position where we say that every republication of a defamatory statement gives rise to a fresh cause of action. However, when we look at other jurisdictions like the UK, there is now a single publication rule, and especially in light of the internet. So Section 8 of the Defamation Act of UK, the 2030 Act, says that everybody who publishes a defamatory material is not exposed to a fresh course of action every time that defamatory material is accessed. For example, by the time you post something on Instagram, it is there on the app, but different people will access it, seeing the number of views and everything. Your post can get like 1 million views and so on and so forth. But the point is, under UK law now, anytime somebody reaccesses that post, there is no fresh course of action. That's just in UK though. But in Nigeria, we still maintain the old common law position. So if we want to apply this to our case, you see that a lot of people accessed it. In fact, some other blogs reposted it. So since we still maintain the multiple publication rule position here in Nigeria, every single time somebody accesses or views that in defamatory post, it gives the plaintiffs that we have identified in this case, that is Story Sinks and Slingers Connect, a fresh course of action. A fresh course of action is created. And also for the blogs that went ahead to repost it, did not send them, but they went to go and repost it. Yes.
I like that.
Yes, thank you, man. That also applies to republication. And then to the plaintiffs in this case, they have fresh courses of action against them.
Okay. So thank you, Grace. And what you have said about that, well, we'll take that maybe when we are looking at some of the defenses, because I would like to know what is the position of common law and if there's any extent new developments about, those who are innocent disseminators. Okay, in this context. So maybe we'll take that. I don't know who wants to take that, but I will invite Lawrence to speak to the context of what you're talking about.
Yes. So the next issue, which is the sixth issue, is whether or not there are any differences applicable to Mark and the bloggers. And the general rule concerning defenses is that once the defendant has published a defamatory statement, he will most likely be liable for defamation, but it is not a blanket cover, right? So he will not be liable where, let's say, there's a justification for that statement, right? And so with respect to justification, you're talking about if, for example, there are inaccuracies in the statement that was made, right? If there are inaccuracies in the statement, then the statement, the plain meaning of that statement would not be defamatory because there are inaccuracies in the statement that was made, right?
I think, to broaden it up, the defense of justification actually has to do with truth.
Yes.
So, like, if, because the tort of defamation actually protects the reputation of a person that is true. So if the person is not actually entitled to that good reputation, that means if that thing that was saying about you that is defamatory is actually true, then you don't have the person will not have any defense.
Very correct.
Yes.
Very
So
correct.
I think one case that actually supports this is the case of Lewis versus Daily Telegraph. So what happened in that case was that a fraud board in UK, I can't really remember the name of the body, but that board actually started doing investigations on the telegraph company, right? And then a newspaper vendor, they wrote on it and they're like, oh, XYZ board has actually started investigating these people. So during the course, the company, they were angry, they brought an action against the newspaper people. And then the court was like, but they're actually doing an investigation against you. It's not, they did not say anything that was extraneous. The problem in that case was they were trying to say that, they are insinuating that we are guilty. And they said, no, we just said that they are investigating you. They don't say that you are guilty. So in that case, that's just how the defense of justification comes in. Yes.
Okay. So justification is just truth. In fact, it's called the defense of truth in some other jurisdictions. Okay. So if it is true, then you are not entitled to any protection generally. Even though there are some issues beyond that in other jurisdictions that we can discuss further in another presentation. Maybe Lawrence wants to list some of the defenses that are available. Just give us a list in defamation generally, and then tell us the one that you think applies. Do you think justification applies in this context?
No, I don't think justification
So
applies.
it doesn't apply.
Yes.
Okay. Is there any other defense that you think?
So we have defenses of fair comments and also status bar, for example, where you bring an action after the time, the 6-year period allotted for the institution of an action.
Limitation of time.
Limitation of time, yes.
Okay.
Then we have the fair comment justification.
Okay. In the light of this case scenario, would you say that any of these defenses applies? A case that involves someone telling a blogger something and then other bloggers are put it. Do you think there are some things that you would like to have? What about Grace?
I don't think so. What do you
I
think?
think, in my opinion, right, because what we've given this problem question, there's nothing, like, it's a very black, if the defendants can prove that, yes, is actually the truth, it's actually true, then I think the defense of justification might find a way to
Okay.
apply. So in this question, it was not stated whether or not anything was true or not. If they can prove that it is the truth, I think that defense will apply. Also, I think depending on the timeline, we've also talked about it being statute barred. And in Lagos, we can see it under Section 804 of the Defamation Law of Lagos State. So if they wait more than 6 years before bringing that action, it will apply. Another one that I think I've come to know is still under the Defamation Law of Lagos State is like the defense of maybe when you retract or offer of amends, right? It's not a complete defense. It is a partial defense. So if the defendants can also prove that, oh, maybe they tendered an apology, they said the court might maybe consider it when they are granting out remedies or things like that. So, and another thing is death of the plaintiff. Now, the question did not say anything about anybody dying or anybody being alive. So, for example, if the plaintiff does die, if terminates, because defamation is a right in person now. So, if he dies, then the right of action actually terminates along with him.
Okay. I suppose that's the last
Yes.
okay. But let me just ask you a question, because now you know this defamation case is about something that is online. So, and you know that the age that you are living in, these are things that could be forwarded, shared. Maybe somebody puts it from that blog on Facebook, on YouTube, or WhatsApp and whatever. Do you think that there could be liability on this under this chain of interaction?
Yeah, so earlier in the video you mentioned something about innocent disseminators.
Okay.
So it's not every time that if sometimes you might do something innocently, right? So if you push something out and you actually had an honest belief, you did not know that it was defamatory, etc., you might get some sort of maybe excuse under the law. However, there are some things that you have to prove. It must be proven that you reasonably would not have known that thing was defamatory. I can't really remember the case right now, but it had to do with something about, I think, Obafemi Awolowo. There was a book that was circulating that contained defamatory material about him, and the publishers were selling the book, and the defendant in this case brought an action against him. They tried to rely that, oh, we're innocent disseminators, we did not know. But the court in that case was like, look, the title of this book is very interesting. It's a very interesting. Yes, you should have noticed. You should have. So yes. So you must not be, let me say, lazy or negligent on your part in checking whether or not that thing is defamatory. So if you just posted it like that, fine. But if you ought to have checked, then you'll still be liable for defamation.
Now that's very great. I think that you are really a critical group. Now, I would like to say, so moving further, I think that's a very, very good exposition on this case scenario. And as lawyers, we know that when it comes to communication, we are in communication age. In fact, we sell information now, and it's flying all around. So the law of defamation continues to evolve. You know that the internet is a borderless society, but law is not borderless. Law is jurisdictional. So you need to also, as you move forward in your research on this topic, consider that in this kind of scenario, you could have some, for instance, defendants in other jurisdictions. And so you need to understand that defamation is based on the laws of each jurisdiction, unless you have treaties that have a framework, maybe global or regional. Okay, then you have some developments that have occurred in the communication world. For instance, you could, assuming this publication is put on any social media platform, Facebook, whatever, you could inform them to take down notice.
Yes.
So there are some practical steps that can be taken beyond the law. And if you, for instance, tell the platform that they should take you down because it's false or for whatever reason, and they refuse, the law of the country would determine what would happen.
Yes.
If it's England, if it's Nigeria, so you need to find out the legal framework for that. So if they refuse to take it down, then there's likelihood of liability in some jurisdictions. And then there are jurisdictions that have straight laws and say either way, the platform would not be responsible really for whatever is put on their platform. I know the law is evolving in that respect. But like you said, some things are clearly some things that you should interrogate, and it depends on the platform you are dealing with and what they have put down as a structure for that purpose. And of course, you could write a letter, like, just like you have under the common law where somebody can make offer of amends, you could also write a cease and desist letter, or so the person, and that could also affect what happens when litigation occurs. So essentially, therefore, those are global and broader perspective to this case scenario that you have given us. I know that the law would continue to improve in this respect. So I would like to thank the critical group for this critical analysis and exposition on the position of the law of defamation. And I hope that from their insights you have seen that the need for us to understand both the meaning of the thought of defamation, the types, the elements of defamation, and then the possible defenses and the evolving field of online defamation, as well as the remedies that are available. Thank you very much. Thank you. A round of applause for bringing these insights on board. And to our viewers, I think that I'm sure you have been better educated on the thought of defamation. We expect that you join us at other presentations where we'll be looking at other aspects of the law. And as you do so, please don't forget to make your comments known to us, to like the video, to share the video, and to subscribe to the channel. See you once again at the next presentation.
Bye.
Lights, camera, action.